to the Legal Weekly Wine, where we talk about the week's hottest legal topics. I'm Virginia Tehrani. I am with the Law Unscripted, and I also run Tehrani Law LLC because you never need a lawyer till you do. I am so happy to have with me Dr. John Weil from Middle Tennessee State University. He is the Dean of the Honors College, and I'm thrilled to have him today. Most days I am, but even especially today, we are in the Supreme Court cases summer. We are right up on it. We are in June. We have had some great cases already. We've got the Takings Clause case with the little old lady. But this week, we are going to talk about Jack Daniels and squeaky toys. So we are going to hit that Supreme Court case, which who knew that would ever be a Supreme Court case. And we are also going to talk about Trump's indictments, the new ones by the DOJ in federal court. So we have got those two huge topics. We're going to hit some others. The Supreme Court decisions keep coming down. And that's why Dr. John Weil is here with us, because he is a preeminent constitutional law scholar about the Constitution, the amending process, and how it all works together. So that's a lot of me speaking. Welcome, Dr. Weil.
Good to be here.
So I think you might be as excited as me.
I'm pretty excited. I mean, I live in Tennessee. By the way, I don't drink whiskey, but I have to defend the pride of our state. And one of the things I think that you found when you traveled, am I right, when you went to France?
Yeah.
The two things that everybody seems to know about Tennessee is that it's a home of Elvis Presley and Jack Daniels.
That's it. That's what the state is. So, well, I mean, Nashville, country music,
sure.
But of those three things, Jack Daniels is such a preeminent fixture of Tennessee.
Yes.
And that's where you are.
That's right.
And that's where I grew up. So, yeah, this is very exciting. I have Jack with us today. I know you don't drink whiskey, but I do. So for happy hour,
I didn't hear that.
I know. In addition to being this amazing scholar that he is also my dad. So doing this weekly wine with him has been quite a trip. Normally we drink wine. Well, he doesn't, but normally I do on the Legal Weekly Wine. And this week I said, okay, we're getting away from wine. It's the first time in this series that we have not done wine, but it was appropriate to do some Jack and Coke today, our famous combination. And I told him, having to tell your dad that you are drinking whiskey and you want him on a show so that you can drink whiskey while he watches has been hilarious.
So it is. And here, I thought I was dressing up like Jack Daniels today, and everybody tells me instead that I look like Colonel Sanders. So go figure.
That's another iconic figure, and we're talking about trademarks anyway. So
yes.
I think it's extremely appropriate to do that. So cheers to happy hour on this Friday. I will not drink much. I only poured one shot, not two. So hopefully you'll grab your glass of Jack today or your favorite wine. And we're going to start then. Cheers. No clink today, but very nice. Okay, so we have...
If we don't have a click, we could have a squeak, couldn't we? Can't hear it.
Oh, no.
There we go, a little bit.
Jack and squeaky toys. We tried to find the squeaky toy that this case is about, but we can't find them anywhere. They're like sold out. And I think, this case is making them even more popular, which is probably a problem based on the ruling of the court. Yes. And probably I can't get them anymore or shouldn't. But we are going to have a squeak for today. My dogs are going crazy, so if you see them in the background, it's the best time to have the dogs because it's squeaky toy day. All right, so Jack Daniels Properties, Inc. versus VIP Products LLC.
Yes.
All right. So
Trademarks case.
yes, trademarks case. We don't normally have these in the Supreme Court, do we?
Not that many. There have been a few. There was a case a couple of years back as to whether a musical group could call themselves the Slants, which was sort of a play on a stereotype that's often used against Asian Americans. And previously, the trademark office had refused to offer it, but the court decided in that case that it was an example of free expression, and that's really sort of what developed in this case. It's at least indirectly a First Amendment case.
Absolutely,
because the trademark company is saying, and I'm trying to remember. You remember what they call it? They call it instead of Jack Daniels, it's
Bad Spaniels.
Bad Spaniels. But basically, they develop a squeaky toy in the shape of the Jack Daniels bottle, which is fairly distinctive,
Extremely.
Rectangular sort of square bottle, and the words themselves that they use on the trade or the bottle itself. The label also resembles. It's also black and white.
Right. It has
a number 2, which was meant as a reference to dog do, which you can imagine Jack Daniels was not terribly happy about.
Oh my gosh, yeah, because they have the number 7 on their branding.
Right.
This is their full branding, and instead of the number 7, it said, just like you said, the number 2, and then it said something else. What was? The old number 2 on your. Okay, so.
Yeah. On your carpet, if I remember.
Yeah, on your Tennessee carpet. So instead of the old number 7 Tennessee sour mash whiskey, which is what's on here, it became the old number 2 on your Tennessee carpet. So I don't have the squeaky toy for it. But yeah, I mean, it's such a distinctive label. Everybody knows it, even if this is covered up.
Right.
It's
the bottle
branding.
shape itself is part of the package, if you will.
Exactly. It's so distinctive, and that's the whole reason, or one of the reasons it can be trademarked, as I understand.
Right.
So what does establish an actual trademark?
Well, the court doesn't use this analogy, but there's an old analogy that says if something looks like a duck and they say quack, but squeaks like a duck. Exactly. Et cetera, that it probably is a duck. And basically, I mean, there's arguably some free expression going on here. This is, and satire, this is more parody, I guess, than satire. But there are cases, for example, you may remember years ago, there was a case involving the Reverend Jerry Falwell Sr., in which there was a play. It was very, very crude, but basically claimed that it was about his first time, which is, whatever the drink was, had an advertisement on the first time. And this was his first time was supposed to be with his mother in an outhouse. Again, it was very, very crude.
Yeah.
And he sued. I mean, rightfully, he was hurt by this. And he sued for libel, I guess it would be, rather than slander, but sued for libel. And in this case, basically, the court said, there's free range, particularly when it comes to mocking public figures. This was sort of a stab at the perceived hypocrisy that sometimes pastors exhibit. And in this case, and I think the further was that really nobody really believed this, believed that it was meant to be true. It actually said at the bottom. And perhaps for that reason, if I recall, this trademark does say at one point in fine print at the bottom that this is not produced by Jack Daniel. But
correct.
What Justice Kagan, who wrote a unanimous decision, by the way, for the Supreme Court,
which is unheard of.
Well, relatively rare, particularly in a case that could implicate free speech. Now there's some concurring opinions, but they don't have to do with they have to do with some of the reasoning in the case rather than the case itself. But essentially what they say is that, if you were choosing squeaky toys, you saw this one for Jack Daniel, you might actually think it was produced by Jack Daniel.
I would have. If I'd seen it, I would have.
Right. And therefore, the primary element in the case, there's something known as the Rogers test, which probably we don't need to get into.
Yeah, but I think it's important because one of the concurring opinions actually talked about it and questioned whether it should be used.
Well, the court itself basically said, we're not saying yay or nay on the Rogers test, but basically it was a test that said if there's, it gave primacy typically to free speech claims.
For expressive works.
Right. In this case, it said that there was a prior decision that had to be made, which is it actually playing completely off the trademark in a way that would hurt the reputation or imply that it was done by Jack Daniel. And so if you're using the squeaky, if the toy looks so much like and could be confused with the products of the company, then you really, any expressive element is so minor by comparison. Trademarks are designed. Right. Trademarks are designed to distinguish one product from another.
Right.
And the court says, if you like whiskey, you might like Jack Daniel's more than you would another brand. So it is a way of identification, and having other companies emulate your trademark, even if it's in jest, could possibly destroy the value of the trademark itself.
Absolutely. I agree with it. Of all of the things, I actually agree with this decision. There are some that I'm like, I can agree in part and dissent in part. Sure. But this one I do actually agree with because I think it does both. I think part of the problem with, a trademark case is you're saying it like you did, it dilutes our brand and or it's using our product to gain profit from somebody else. And I think that's exactly what's happening in this case is I think the brand is diluted because it's passing it on to other products. And Jack Daniel's, to all of my understanding, only sells whiskey. That they might
someone has told me that they now manufacture beer, but I don't know that for a fact.
It's all alcohol related. They're not in the business of selling squeaky toys or any other products that you can get, except maybe some T-shirts or something.
Barrels, I believe. If you go to Lynchburg, Tennessee, I know the stores there have distinctive barrels with Jack Daniel's written on it, which I think people use for alcohol storage.
Which makes sense because it's all what they're trademarking is alcohol related. So what they're producing, what they're making money on is alcohol related, not dog toys. So someone else has come in and is now making money on the trademark, the branding that they have, instead of giving it to Jack Daniel's. So they're making money, and it's diluting the brand because it's going away from the alcohol. And I thought these comments, these quotes from this case are hilarious.
Kagan, I love, she starts out by saying, let's see, something to the effect that products, that one rarely has a case in which one can say the words whiskey and squeaky dog in the same sentence.
Yeah, this case is about dog toys and whiskey, two items seldom appearing in the same sentence.
Right.
It's hilarious. And then the other one it was so funny to me is she's arguing that, they'd infringed upon it and diluted the trademark by leading consumers to believe that the company had produced the toy. And in her words, she says, by associating the famed whiskey with dog excrement.
Yes. Yeah.
I mean, what a case.
But by the way, she gives a semi-endorsement, if you've noticed. She says, funny. most of you probably, if you go to your liquor cabinet, can look and see what Jack Daniels looks like.
That's so funny. Yeah. So it's one for the books, and I love the arguments, and I think the Rogers case is important here because in my mind, it doesn't have to be a true test. Hi, do you want the squeaky toy? I'm going to have to pass off the squeaky toy to one of my dogs who's dying for it. It's their favorite legal weekly wine day.
I think I saw one of them trying to drink your whiskey too.
Yeah, I have to check on that. But everybody's excited for today. But I think, goodness, where was I headed? The Rogers test. For me, it's not a Supreme Court case. It's a Second Circuit.
Right.
So I'm
but it's
surprised.
A test that's been used. Right.
Yeah, it's been used so widely, but I'm surprised by it because it's not a higher court. And I know there are reasons to get up to the higher court versus not, but I would like to see a case challenge the Rogers test and bring it up.
If you are an attorney and you have read this case and you have a chance to challenge the case,
Now's the time.
2 or 3 judges specifically saying they probably would overrule it.
Yeah.
And the unanimous court saying we're not really applying the test because we don't even get to that point.
Correct. Yeah. And the interesting part, so the Rogers test is looking at trademarks and saying an expressive work doesn't violate trademark. It is a First Amendment freedom of speech issue. But it was so narrow in my mind, because it was about, what was it, Grace Kelly, who was suing?
Yeah, it was a movie, or Ginger Rogers and Fred Astaire. There was a movie that used characters that had similar names. I think it was actually an Italian movie, and it was like, people sort of going to get an inside joke here, but it's not as though you would watch this movie and think you're seeing Ginger Rogers and Fred Astaire.
Right.
Or Grace Kelly.
Exactly. Yeah. And to me, it was limited because it was the title of the work is artistically relevant to the underlying work, and it's not explicitly misleading as to the source of the content. Right. And to me, even if you applied the Rogers test, it would fail. Because in my mind, Jack Daniels, the squeaky toy is explicitly misleading as to the source. Even though it says this is not a Jack Daniels product, if you just pick it up or look at it, you think it is coming from Jack Daniels, that they're doing a parody of themselves, and they're not. Right. But anyway, squeaky toys and whiskey.
It's a great case.
I love it. Between that and the little old lady case, can we mention that for like 2 minutes? Yeah.
That's, I wish I could, you have the name of it? I think I had that ready for last week and not this. But
yeah, I did too, and we did.
There was a case in Minnesota, basically Minneapolis, if I remember, where a woman has moved out of a condo, probably into like an assisted living.
Right.
And partly as a result, she had not paid her taxes. And the state ended up selling the condo and pocketing all the money. She owed like $15,000 and they took the whole $40,000. Now it turns out she may owe the rest in HOA fees or whatever, but not to the state itself,
not to the government.
And basically, right. This comes out of the takings clause of the Fifth Amendment. Which also applies to the states through the 14th Amendment.
Right.
A due process clause, which is the notion that, for the government to take property, they have to provide just compensation. And when they take property, it needs to be, they shouldn't be taking more property than what is needed for the payment. Now, an area that's related to this, where I frankly think we need a little bit of work here too. There are some rules where you find somebody hunting on government property and you can confiscate their vehicle, or you find somebody carrying X ounces of drugs and you confiscate the house where you find it or the vehicle. That's a little bit different issue. It's sort of a criminal law, almost an 8th and 14th Amendment issue. Can a punishment be so disproportionate to the crime to which it's being applied as to constitute cruel and unusual punishment? And I think the answer is yes. I think there are cases where government, they'd love to pull somebody over on a drug charge in certain jurisdictions because they're going to try to confiscate their car along with it. Yeah. And then they're going to sell the car and put it into a policeman's fund or whatever. And I think there's...
Yeah, that's one of the things that I used to do as a prosecutor is we would have those cases. And if you were on the drug team or drugs, guns, and gangs or whatever the team was, then that was part of your job is you would handle the civil matters where if a car or a boat or a house had been taken because it was allegedly the proceeds had been of illegal activity had been used to purchase them, then that was a takings. But one of the biggest cases that we had, I didn't do it, but I think the house, the boat, and the car were taken. And they had to prove, the prosecution had to prove that that amount of money had been used, not just that drug dealers had bought a house, but that amount of money and particular, funds from illegal activities had been used to purchase those products. And so they can't be illegal gain. So that goes back to the government.
Occasionally you'll find that there's been a case or two, and I don't remember the names, where they will confiscate like $10,000 from somebody in cash and don't give it back. Yeah. And they haven't actually proved the underlying offense. There's sort of an assumption that most people don't carry, $10,000 in their back pocket around with them. But that's
accepting illegal.
There are some reasons that one might carry that kind of cash. If nothing else, just fear of banks or whatever.
Yeah, no, it's interesting. Okay, so let's get to our other hot topic of the week because it started last week and then has culminated this Tuesday in the arraignment. But how many charges do we have now with just this one federal case? Is it 32?
I believe there are 37. And one of the fascinating things about this case is, the first person to tell us that he was under indictment was Trump.
Himself.
Former President Trump, I guess I should say. And my recollection is that he claimed that there were going to be 7 charges against him. And I don't know if that was intentional or just a misunderstanding, but, it's a pretty big difference between 7 and 37. Now, most of the charges are, they're individualized to, here's a document that dealt with nuclear secrets.
It's per
Here's a document that dealt with a possible attack on Iran. Here's another document. So the 37 in a way is deceptive. I mean, the primary charges, you have a host of charges involving illegal retention and possession and retention of documents. But frankly, the more serious charges, I think, have to do first with conspiracy and then also with obstruction.
The obstruction of justice.
And this goes, by the way, Trump's primary defense to the extent that he has one. I mean, his primary defense is he's a victim, he's being persecuted. Probably everybody everybody who gets indicted maybe feels that way. I don't know. But the primary problem that he has in distinguishing his case, like I say, then his second defense is basically, well, everybody does it. Right. They found some top secret documents in Pence's house. They found some in Biden's.
And then the
Hillary Clinton didn't take due care when she did emails. The apparent difference, and again, this has to be played out in court in front of a jury. So one doesn't want to prejudge here.
Right.
But in each of these cases, it appears that remedial actions were taken when they were, when the government said, you have a document to come on in and find it. If they found it, to take it away. There wasn't, well, they're my documents because I'm a former president or a would-be president. That's primary difference. And frankly, I would say this, whether this is a Democrat or Republican, liberal or conservative, anytime a person who is indicted begins denigrating the prosecution or attributing bad motives to it, I think it's a time of real danger, particularly for someone, who once headed our government.
Yeah.
Particularly Republicans used to be the primary defenders of the Justice Department
Police
and the FBI and the IRS, you name it, that they were, that was law and order. And
well, technically, I mean, you're right. Republicans generally have been on the side, like you said, of law and order. Usually, or they used to be pro-police, pro-gun, that it was a government system.
Right.
And it is interesting whether it's creating a shift or it has shifted or there's an attempt to shift the idea of, yes, we're pro-government, but our own.
The most prominent new term, and I don't know if I've heard it before this one or not, but the term weaponization.
Oh, interesting.
In my, Trump says there's been a weaponization of the Justice Department, of the special counsel.
Okay.
Arguably, in a system of separated powers, particularly, if you have a president, the president is head of the Justice Department.
Right.
He's commander-in-chief of the armed forces. He also has the primary duty to enforce the laws.
Right. The
that's his
executive
job.
in chief.
So,
yeah.
Yes, a former president can say, well, I'm being prosecuted because we have a Democratic president. But as far as I can tell, Biden has done as much as any president could not to politicize it. He's actually stayed out of any question. If they ask him what he thinks about it, no, I'm not going to comment on that. His attorney general did not bring the indictment. The indictment was brought by a special counsel. And by the way, the special counsel, Walsh, actually has Tennessee connections. He was well established here for prosecuting local governmental officials who were engaged in wrongdoing, including a sheriff here in Rutherford County.
Oh, my goodness.
So he has, to my knowledge, none of these, as far as I could tell, were at all politically motivated. He was, investigate this. Did a crime occur? He concurred. He believed that they had and successfully prosecuted them. Whether he'll be, I think the big problem in the Trump case is going to be so difficult to get a jury that is not just reflexive, pro or anti-Trump, or pro or anti-government in such a way that they're just not going to listen to the evidence. But as far as I can tell, and you've read a lot more indictments than I have, but this seems to be a pretty specific indictment.
It is.
There are apparently tape recordings of specific conversations in which the president, suggests telling people that there's nothing there or hiding the evidence. This is, I wouldn't want to be on the receiving end of an indictment like this.
Yeah, and it is very specific. It's interesting because I think it does go into the differences. I'm trying to keep my personal opinions out of any of it. He keeps bringing comparison, especially to Hillary Clinton and the emails. But it does seem like, at least in the indictment, now whether they can prove it or not, I don't know, but the exhibits they've attached seem pretty, try not to curse on here either, seem pretty bad. Yeah, there we go. Against him is if they can be proven, and they're using his own words and his own actions in the public, where do I think Hillary should have used the private email server or passed secrets through it? No, I don't. But
if I may add here, a lot of this goes to motive.
Yes.
The Comey, who was head of that previous investigation, if I remember, at least indirectly.
Yes.
they were unable to find an intent to violate the law. So mens rea, I believe, is the term. So I heard somebody the other day saying they neither knew law nor Latin. I knew just enough to make me dangerous here.
Yeah, and that's right. It does in criminal law? You have to have both. You have to have the actus reus, the act, and the mens rea, the intent. And I think they're proceeding based on the indictment, the words in the indictment, on the idea that he had the intention to keep the documents. Yes. To not turn them over, and over a process of about 2 years, instead of saying, oh my goodness, yes, I have documents, here they are, take them back, you can search, you can keep them, that it seemed to be a process of keeping the documents, wanting to keep the documents, intending to keep them, and intending not, to obstruct the FBI and the archives and anyone else in the government from getting them back. So I think that is the specific statutes that they're using too. I mean, it's not treason. The Espionage Act is what they're doing. And I thought at first the title of it's awful. Is like, oh my gosh, he's selling government secrets, but that's not the purpose of that act under what they're using for the language. It's the retention. It's after request. Upon request, it's the retention of the documents without turning them back over, I think is what he's been.
I think so.
With.
And I mean, the great unknown, and here's where, and when Nixon was under investigation, it kept coming back to initially they couldn't find a smoking gun, so-called smoking gun.
Right.
And eventually they found it. They found him talking to an aide, John Dean, I believe it was, as counsel, basically saying, here's what we need to do.
And it was the tape recordings, right, from the Oval Office.
That's right. And a lot more recordings, actually, in that case than in this. But the great unknown in this case and the great potential for it getting much bigger, and I say only potential because I don't wish it and I don't know it.
No, yeah.
But is why did he insist on keeping the documents even after he was told that they didn't belong? And there is, by the way, the Presidential Records Act of 1978 was passed in part after Nixon. Because of Nixon. To keep a president from, in his case, there was a fear that he was going to destroy documents, which would, undermine the historical record. So that law specifically says that a president, there are certain documents that the presidents can keep, but the others actually belong to the United States. So the question is, why does Trump want the documents? And the less damning, if you will, reason would be he just likes to keep that, he likes to count his money. He likes to count, and maybe he wants to show off. Look what I had access to. Right. But there is always the possibility that he hoped to monetize some of these.
I think that's the fear.
Particularly, hopefully not with China or Russia, but maybe with Saudi Arabia or Turkey or countries that we would have some association with that, hey, let me tell you some information that might be of help to you as we do business together. I hope that's not the case, but it's hard to imagine exactly, why otherwise, why do you want these documents?
Right. And why would you tell your valet, go get them and put them in the bathroom?
Yeah. I was rather hoping that I could tell the government I had a secret document and they would have to come. As I have probably as many boxes of every time I write a book, I get like 3 boxes of articles, and maybe they could come through and organize them for me and figure out a storage spot.
Well, I told you on Sunday this week that my husband found there's so many memes and videos going on about them, parodies and satire about them. This issue is the funniest one that I saw was this video where it was Indiana Jones clip of them sealing up the box for the Ark and, putting it into the storage unit for the the United States. And then it pans over to the picture of the documents in the bathroom, and it's got the Ark in the bathroom. I was like, oh my gosh, that was really the funniest thing that I've seen. Whatever you think of the indictments, that was pretty funny. But I do think, so correct me if I'm wrong, for Nixon, they didn't actually get him on the Watergate scandal. They got him on the obstruction and the cover-up.
That's right. The cover-up is almost always worse than the crime.
And I think that's the
pull the
premise
Band-Aid
here.
off, acknowledge, hey, and you have some excuses.
Right.
I thought to the last minute that I was going to win this election.
Yeah.
I was counting on Mike Pence. He betrayed me, but had he not, I wouldn't have to move any of this. We only had X number of days between that and the time I had to leave office. We packed him quickly. I'm so sorry if I got documents that I don't need.
Yeah.
But, one of the fascinating things about, and here, some people are saying that Trump is actually benefiting politically, at least among the Republican base. I don't think he is.
With the indictments.
Yeah.
Okay.
But that, he loves playing the role of persecuted. And it's a bizarre role when you think about it.
Yeah.
How many times do we consider that the government primarily goes against white billionaire, ex-presidents? I mean, they're not generally in, if the Caroline Products footnote.
Don't know that one.
The areas that demand special attention, and one are discrete and insular minorities. I've never considered the ex-presidency as a discrete and insular minority that the Justice Department typically targets.
Well, there are only so many.
Yeah. In any event,
there are a minority of Americans.
But one of the things that I find fascinating is, I would ask his supporters to consider, put aside for a moment whether, my own view is that these documents are not his. Mm-hmm. I've read the Presidential Records Act. I think it's pretty clear.
The law.
Now, an ex-president can ask special permission if they're writing a autobiography or memoirs. They can ask permission to go back and examine documents and get it on a case-by-case basis. But I think it's pretty clear that he doesn't own the documents that he claims to own. But even if you think that he did, is this appropriate behavior or is it reckless? And to me, the notion of, I deal as an academician, it's not quite the same level.
Right. But
if we have a document that has a student's social security number on it, we have to delete it.
Exactly.
I don't know that we can even store it, but if we stored it, it would have to be in a locked case.
Yeah.
And we take that very seriously. We have, we're constantly getting instructions, make sure, there's no personal information in any of your files that someone could get.
Yes.
And here we're dealing with nuclear secrets, plans of attack, American weaknesses. Why would you not want he can afford to buy, put some locks on some doors.
Mm-hmm.
And you don't store things like that under pipes that could leak and the like.
Yeah, and I think that's exactly right. Is there some level of fiduciary duty as the president? And
right. Good legal term for it.
It is, and that's how I've been thinking of it. Is like your school analogy is me for an attorney. I have client confidentiality, and I have very strict rule of ethics that I have to store my client's documents just in a specific way for a specific time. I cannot share them with other people. I have to keep them, but it's not because I want them or I'm hoarding them or I'm showing them. And I can't boast about them. I can't say, hey, come look at this. I've got something in here, but I can't show you, or I can't tell you I'm not supposed to. I have very strict ethical rules. of how I deal with my own clients. And no offense to my clients, but it's like that's not national secrets.
Right.
It's not something that I think could deal with nuclear warfare or nuclear secrets. It's certainly nothing to do with Iran. So, just as my clients who are not nationally related and not national figures, as much as I have to keep them confidential and secret, and, I even have to file paperwork, the same thing, that I'm not keeping social security numbers and credit card numbers and storing them and using them. Why would a president, you would assume, and maybe there's not a case and maybe there's not law that does need to be made of, is the president a fiduciary? And if so, what are his duties with regard to these records that are for the United States? So,
yeah, and I don't know. Again, I mean, I know that under the Presidential Records Act, once he leaves office, they no longer belong to him. One of the fascinating dimensions of this, and I'm a political scientist rather than a lawyer.
But the Constitution and the
absolutely.
laws.
But one of the fascinating aspects of this is, why is Trump running for re-election? And one reason, the only way it's possible that the only way he will stay out of jail is by being president, because I think it would. Now, we have, by the way, trivia question of the day.
Oh,
do you know what person ran for president while he was in jail?
Oh, I don't know.
He's not a main party candidate. Eugene Debs.
Okay.
Ran as a socialist. Got 3 million votes, if I remember.
What year?
1912, I believe. It could be 8, but I believe it's
early 1900s.
Somewhere between 1908 and 1920, one of those elections. But of course, what we're likely to see here is Trump's best legal strategy, and you're going to know legal strategy a lot better than I am. But his best legal strategy might be that of delay.
Yes.
If he can keep the prosecution and then we go back to weaponization. Well, if what he's going to do is, if he becomes president, he's either going to
declassify.
I guess he could do that. Although I don't know that would deal with the obstruction.
It may not take away the obstruction charges.
One of the unanswered questions, it's in its 7th edition now, my companion to the U.S. Constitution. One of the questions that I've raised but never been able to answer is, can a president pardon himself?
And I think I've seen quite a few articles raising the same question, and nobody seems to have a definitive answer. That may be something that's going to the Supreme Court. And that's what I'm watching everywhere, is so many people have said, no matter what is happening with this case, that we are likely to be entrenched in years of continuing litigation, appeals, possibly Supreme Court involvement, just because there are some novel issues that couldn't be preempted. As you and I know, there has to be an active case, right? It can't be maybe
actual case in contra. They're not going to tell you whether the president can pardon himself until one actually tries to do it.
Exactly.
And that would be a mess. This is one of the few times, by the way, where if there are implicit natural law principles in the Constitution, it may be it. No person should be a judge in his or her own case. That's not written in the Constitution, but neither is the presumption of innocence, right? Neither is the exclusionary rule. There are things that aren't in the Constitution that just seems so fundamental to a justice system, then one could argue that, every reasonable, however you would phrase it. So it would pose an interesting question of constitutional interpretation for sure.
Yeah. All right. So this is extremely interesting. I mean, the hottest news even Trump's prior indictments in New York, that was really hot. And then, but this is just.
Well, and by the way, there's a new development there, and I don't know how far it's going to go. But this case that Carroll did.
Yes, the civil case.
Yeah, Jean Carroll. You remember, she got a judgment not that long ago on the basis. I think ultimately what the jury decided was that he had engaged in sexual harassment, but more so that he had subsequently libeled her by his comments. Correct. And of course, when the judgment came down, and it was fairly substantial, it was a monetary judgment. I believe this is civil, large. Right? Rather than it wasn't a criminal rape case, but it was a civil damages case.
Correct. And they decided instead of rape, it was sexual assault, but it was also defamation, and I think it was $5 million. We did. I believe that's right. Weekly.
But what happened is, as soon as the judgment came down, within the next day or two, he goes out and makes continuing slanderous remarks. Well, if they're not true, they would be slanderous. What the court had considered slanderous remarks. And she says, well, I want more. He's continuing to engage in the same kind of behavior for which he was convicted.
Right. And so it's new acts. So she's not suing on the prior act. She's suing on new statements.
In other words, it's a continuing kind of reiteration. Right. And by the way, while we're talking about Trump, in my judgment, now how it'll come out legally, I'm not sure, but the possibility that Trump could be eventually indicted for incitement to imminent lawless action at the Capitol.
Right, the January 6th cases.
Right, the January 6th. That, in my judgment, would be more consequential than the current indictment based on documents.
Sure.
Causing a riot, or if that would be the judgment, if in fact he knowingly incited a riot and did nothing to stop it, that resulted ultimately in deaths and injuries. And it's far more consequential also in terms of, the democratic system. Yeah. If you're going to create a riot every time you lose an election, we're going to have to batten down the hatches every 2 years, particularly every fourth year.
Exactly.
And so, and part of and of course, there's also a possible suit coming out of Georgia dealing with the election interference. And we may have some prosecutors waiting in line now
to see what happens with the others.
Right. Well, and who gets to go first? Apparently, the general rule, and again, you'll know this better than I do, but the general rule seems to be that federal cases usually take priority in time over state cases.
That is generally true. Whether I don't think it's an actual law, but it's the deferential practice.
Right. But if Smith, and here's the great unknown, I don't know where Smith is on the incitement charges. Mm-hmm. I don't know whether in my judgment, the incitement, if it were to be proven, is a more consequential issue than the issue of documents, which is not to undermine the importance of that one either. But, which would he take first if he got 2 indictments? I don't know.
Mm-hmm. Yeah, I mean, part of it depends on the judges, is when they're filed, what the judges' systems, what the state systems are as far as timing and scheduling conferences and scheduling trials. I mean, technically, because of the criminal case, it's the defendant's right to a speedy trial, which he can waive. Yes. And I assume in these cases that he will waive the right to a speedy trial so that he can delay and can get more information. So the question is, how much will these courts allow that delay? Just because you have a delay doesn't mean you can use it for an indefinite time period. So what will the time periods be in each of these states, in each of these jurisdictions, the federal versus the state for the New York one? And you were saying earlier about the fairness of the trials. As far as venue, we're looking at venue of where these cases are being heard and being brought. And I think the most interesting part about them being brought in Florida, the current ones,
Yes.
is that I think he will have a hard time asking for a change of venue.
I don't think he wants to change the venue.
I don't think he would want to. I don't think he can, because if anything, he's in the best possible venue to get a fair or more partial jury for him. Florida seems more pro-Trump than
It's
most.
a red state. He's done well there. He lives there. Sort of call him a favorite son if you want. I mean, it's an adopted state.
Right. But it's, of anyone who might be favorable to him, it might be Florida. So with the change of venue motions, with the change of venue considerations, the thing that I could see him making as an argument for change of venue now, and I don't know how many people are talking about it, is his shift in view on the governor. That might actually have Floridians disfavor him because of his shift and his alleged disparagement, or possible, depending on how you look at it, of DeSantis.
Well, my understanding is DeSantis has pretty much joined Trump on this one, in saying that he thinks it's a setup, and even implied that he might be willing to pardon Trump were he to be elected. I'm not positive of that, but that's my understanding. It wouldn't at all surprise me if this went to court. Here's one where the voir dire would probably be, as of potential jurors, would be as or more important than the evidence that you presented at trial.
Yeah,
because
and for our
you
viewers,
could easily have a Trump hater or Trump supporter trying to disguise their views
to get on.
And it would be, very difficult. And one of the fascinating things that came out of this indictment is that it wasn't the judge in control; it was actually a magistrate. But the magistrate instructed that the president could not communicate with any of the people that have been involved in this, including his valet, who is also under indictment, but has not yet been able, apparently, to find a Florida attorney.
Right. The alleged co-conspirator, which makes sense. And for those watching who don't know, the voir dire of the jury is jury selection. And, Dr. Weil, I think what you're talking about is it is more important to figure out which jurors get seated than what the evidence is. And, it reminds me, and this is, I hope our listeners understand, and you do, it reminds me of the movie Runaway Jury. Did you see that one?
I'm not sure I have. There's the TV series Bull was based on, the notion that if you had enough computer evidence and did enough research, you could basically predict how a juror was going to decide even before they heard the evidence.
Yeah, there's so many people. You hire people to review juries and jurors and help you choose. It's an industry. Sorry, eating ice. It's an industry.
Yeah, you're slurring your words because of ice. Yeah, I get it.
It's just the cold. They have people who are experts in jury selection that you pay so much money for to come in and help you select a jury. And I think that is where this comes in. And the runaway jury premise is a firearms case, where a plaintiff sues a firearms company because her husband was shot during this almost like an elementary school shooting, but in a business. And the idea was that these two people were trying to get one of them on the jury so they could influence the jury to decide in her favor. And it was this whole, well, what do we say to get picked? What do we not say to get picked? Do we, use our own opinions, or do we actually put forward another so that people think we believe in one way, but we don't? So there is the idea that potential jurors may want to be selected and may choose to reveal or not reveal things that they really believe in order to be selected.
By the way, usually if you tell people you're a college professor, they dismiss you from the jury. I don't know if the same is true for lawyers or not.
Oh my gosh, yes.
The one time I was called, as soon as they found out, that was pretty much it.
That's funny.
As Bill Barr said, I was toast.
Yeah, I've been called for jury duty, but I have not been sat as a juror. I would not seat me either as an attorney, and in my juries, I don't want attorneys. Because they do know the law, but sometimes they view the law. I mean, there's a reason we have opposing parties and opposing sides,
Right.
is because I view the law one way, they view and argue the law another way. So I wouldn't want an attorney on the jury.
Something that might be of interest to your listeners are the two types of challenges for calls and peremptory.
Yes.
For calls, you have to. And here I don't know if you ask somebody, what do you think of Trump? And they said, I think he's the best president we've ever had, or I think he's the worst president. Would that be for calls, or would that be peremptory? I'm not sure which it would be.
That
the
would
one
be
you have to give a
peremptory.
reason, the other you don't.
It would be peremptory because you would choose to dismiss him, but it's not for cause unless you can prove that their thoughts that he's the best president will lead them to be prejudiced in their opinions, that they would not be able to be impartial or fair. So then the follow-up questions would be, well, sir, because, I understand that you think he's the best president, would that, does that mean that you cannot judge the facts and the circumstances that you hear in this case and only rule in his favor? So there would be subsequent questions that the judge or the attorneys would be able to ask. And it's hard because the judge will be like, don't you think you can still be fair?
Right.
They're like, oh, I think I can still be fair. And it's like, do you have to ask it as a leading question?
Yes.
Can't you ask it as, what does your view on his presidency, how would that affect your decisions in this case, rather than don't you think that you would be fair? And it was like, wait a minute. So yeah, those questions for cause would be, no, I would only rule for Trump. I don't see it any other way. That's a dismissal for cause.
Well, or if you had worked maybe for a Trump campaign, or you had contributed a substantial amount of money to him, or you had, you were a member of the Bedminster Golf Club.
There's a presumption of bias and a possible dismissal.
Or you regularly eat at Mar-a-Lago. All of these could be possibilities.
Absolutely, and generally, if you know somebody, if you personally know or have interacted with any of the parties, including the attorneys for the parties, any of the witnesses, generally you are dismissed for cause. Even if you can say, you'd be impartial. I've had in my own community, some of the jurors have known me and they're just dismissed, whatever it is, because they would have an opinion about me, not necessarily my client, but my client because they know me.
Right.
So there's a presumption of bias. So yeah.
Well, again, I guess the other possibility is a plea bargain. Trump doesn't seem like the person that would do it, but as trials approach, I mean, the question is, I saw a very fascinating question as to whether could you put Trump in jail? And one of the persons says, no, you can't, because he's guaranteed Secret Service protection, and there's no way that you could have Secret Service protection in jail.
Oh, that's interesting.
I don't know. I mean, maybe you could do house arrest or Mar-a-Lago arrest. I don't know what it would be called.
That's really interesting.
But I mean, it would certainly pose some very fascinating questions. Can you plea bargain in a criminal case? Could you plea bargain a monetary damage?
You could. Sometimes you can exchange, well, I'll pay a higher fine on one charge if you dismiss another, or if you reduce it. It's absolutely a consideration. Now, for him, I don't know that they would do that, because they're like, well, you have money. What does money matter to you?
Right.
But people are not guaranteed plea offers. And that's one of the things in criminal cases is, especially it's surprising, there are some Virginia jurisdictions where they don't even offer pleas. Everything goes to trial, which I would not want to practice there.
The evidence is over. Usually the plea bargaining is, partly it's to save expenses on the part of the state. But partly it's the chance, and you would have a chance, again, because of the difficulty of selecting unbiased juries, there could be a chance that no matter what the evidence is, you would at least get a hung, if not an exonerating jury here.
Absolutely.
And so the state, now what would be fascinating, there have been some local cases, I believe, where, in fact, I believe there was one involving a former mayor of Nashville, but I'm not positive of this, where there was a plea bargain that she would not run for re-election or would not run for office. Now, would that be constitutional? Maybe not, because the only three criteria for president are age, residency, and citizenship.
Right.
And the Supreme Court in Powell versus something or another, Powell versus McCormick.
Wow. I don't even remember either name.
Okay, well, Powell was the Adam Clayton Powell of New York, and McCormick was Speaker of the House. And the House had sought to expel Powell, but they did it on the assumption that they could expel him by majority vote instead of by, where it's too complicated. Congress can exclude people who don't meet the criteria when they're elected. They can say, no, you don't have but the court said the only reason you can, then expulsion is something different. It required a 2/3 vote. So you can't vote to exclude him without making it a vote to expel him, which requires 2/3 vote other than age, residency, and citizenship.
Is it the 2/3 or the supermajority?
It's 2/3 is my understanding for expulsion. I believe you can be excluded. In other words, Congress sometimes has to decide on which group of who has been legitimately elected. Okay. And I believe they do that by majority vote. So you would be excluded by majority vote. But my recollection is that it's 2/3 to expel.
Got it. Okay. Well, this is extremely fascinating. I'm so glad that you have been with me for whiskey, squeaky toys, and Trump indictments.
I don't know if I'm going to put that on my resume or not.
It'll make you famous. It's good. We're going to be put on the map for squeaky toys and whiskey.
Okay. Well, we'll be in good company with Justice Kagan. So.
Yes, we will. And
former law school dean to getting to talk about squeaky toys and whiskey
and excrement.
Yes.
So what a throwback to Tennessee here. I really am glad you joined us.
Don't associate Tennessee with excrement.
Well, that's the problem. That is the whole problem, right? The state should be suing for dilution of its good name and reputation.
Well, maybe so.
So yes, my sweet dogs are here. They keep coming up to play with me with their squeaky toys today. But I'm hoping that you might join us another couple weeks because we keep having Supreme Court decisions left and right now.
Next 2 weeks. I try never to leave the country from June 10th through the end of June and sometimes the first week of July.
Well, I am glad because I'm hoping you'll come back. You are more than welcome and invited. This has been quite a fun and exciting time. So we will look forward to some of the upcoming Supreme Court cases in the summer of 2023.
Okay. Let's hope we're not barking up the wrong tree.
For sure. Thanks, Dr. Vial, and thanks to you guys. I hope you've had a good time. This is the Legal Weekly Wine brought to you by The Law Unscripted, and I'm Virginia Tehrani with the Tehrani Law Office, Tehrani Law LLC, because you never need a lawyer till you do. And this is Dr. John Vial of Middle Tennessee State University. Thanks, everyone.